My content's for educational purposes only. Can't stress enough for you guys to do your own research. Praise my content. If you find any errors, throw it in the comments. None of us have been alive long enough to know all that transpired in the past, and none of us can live long enough to know all the and none of us can live long enough to know all there is to learn. All right, tonight's topic: the UCC connection, how the Uniform Commercial Code secretly took over the world. Okay. All right, seeing through the mud. I send you out as sheep in the midst of wolves. Be wise as a serpent and harmless as a dove. Okay, the UCC took over all contractual arrangements during the bankruptcy. Yeah, you heard it right. The bankruptcy. Since lawful money did not exist as of 1933. Lawful money was United States notes redeemable for gold bullion, silver coin. Look on the bills that we use today from the Federal Reserve. What do they say? You can't redeem them for a goddamn thing. But moving on. The clarity afforded the average Joe when it comes to applying the law to his advantage is about as clear as a mud pie. No transparency. The methods presented in the following are more passive ways of dealing with our legal system, basically by boxing the judge in a corner. Now, I personally have not tried any of this. However, I see the value in this approach. Instead of having to go into court guns blazing, I just ask honest questions transparently, and the rest just falls into place. There are some amazing warriors out there in the field of freeman techniques. Dean Clifford is an example. Sometimes the system is so corrupt there is no choice but to be the warrior, and jail time may be the result. Dean has many different approaches and is willing to invoke the warrior, and like most, humble warriors would rather avoid conflict, settle out of court, and the harmless as a dove approach. We are asking questions in a cooperative manner. We genuinely want them to reveal themselves, but because their system is so dependent on secrecy, they will want to avoid disclosing their fraud. Okay. All right. Here we have a lot of conceptual clarity. Howard Friedman does a wonderful job at articulating the concepts in plain English, making this understandable from my point of view. Howard Friedman reveals the story behind why the UCC secretly took over all legal/lawful matters on the planet. How the UCC works to resolve agreements instead of contracts. How to reserve your rights under the UCC. How to dispel presumptions in court with examples and scenarios. Because of the bankruptcy of the United States Incorporated in 1933, we have been keeping tabs of all our debts using accounting and negotiable instruments. I refer to this as a global financing system, or IOU system, and use terms to describe the concepts involved, but this whole idea is very cryptic. The word statements and bills mean something completely different under commerce than they do in our everyday usage. Winston Shrout has a powerful grasp of this knowledge. Let's look at the definition of a negotiable instrument from the UCC. Negotiable instrument. Okay. Except as provided in subsection C and D, negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order. As you can see, promise or order to pay a fixed amount of money. means the same as an IOU. Okay. All all Federal Reserve notes are IOUs, backed by the labor of the people. I've said this before. The new slavery is our energy and our time. Federal Reserve notes, man. It's how they track the energy output of the people. This global financial system is similar to a global IOU system because no lawful money exists. We exchange IOUs and never actually settle the accounts with real money. Lawful money is backed by real things. Before 1933, you exchanged a gallon of milk for $1, which is a promise to pay gold or silver, real value for real value. Now, because the US dollar is the global reserve currency based on fractional reserve banking that requires interest to be imposed constantly on the debtors, all nations and all over the world are forced under this IOU system with infinite debt due to interest for our children's children. Under this system, you exchange a gallon of milk for a promise to pay nothing plus interest. That's what money became after 1933. Final point, since the money is worthless literally and lawfully, but you exchange something of real value, your labor, we are getting scammed at a phenomenal rate. It is literal slavery. Normal contract law could not function. There was no way to actually provide considerations for services under common law and equity contracts without lawful money. Since common law, criminal, and equity law contracts require remedy or exchanges of real value, the entire justice system was turned upside down. A new system needed to be created which appeared lawful but was not in any true sense. As long as there was a presumption of true law, colorable law, the average Joe would be none the wiser. This is the system we know today as UCC, the Uniform Commercial Code. The UCC deals with presumptive agreements instead of true contracts which have full transparency. 7 elements. And knowing, willing, and intentional consent of all parties involved, instead of contracts being enforceable only if parties agreed knowingly, willingly, and intentionally. Now agreements can be enforced based on essentially cured statements or presumptions. If I make a presumptive statement with material evidence, a bill from your creditor with some numbers on it suggests a contract exists, and you do not rebut this statement, it cures. And you do not rebut this statement, it cures under the UCC given a period of time. Let me read that again. If I make a presumptive statement with material evidence, let's say it's a bill from your creditor with some numbers on it that suggests a contract exists, and you do not rebut this statement, it cures under the UCC given a period of time. This portion of the Julian's debt contesting experience, OPPT, success stories. I don't know what that is. I got to look that up. Okay. describes this concept. A contract requires transparency and agreement of the parties involved. Did you sign with your wet ink signature making a new contract with this third party? No, you did not. And the way they get around that is by asking for you to send them payment, even if it is very small. This creates a legal but now lawful basis for contract which they can then try and use against you. Legal but not lawful. How does that make sense? Let's take a look. The legal basis is referred to as tacit procuration. Tacit procuration. Tacit means understood or implied without being stated. Procuration means the act by which one person gives power to another to act in his place as he could do himself. A letter of attorney. Okay. Procurations are either expressed or implied. An express procuration is one made by the express consent of the parties, and the implied or tacit takes place when an individual sees another managing his affairs and does not interfere to prevent it. Consent for procurations can be implied by failure to respond or stand up and state otherwise. Given these meanings, what we can understand is failure to respond is consent. Let me read that again. Consent for procurations can be implied by failure to respond or stand up and state otherwise. Given these meanings, what we can understand is failure to respond is consent. We must rebut these presumptions that this new third party has any claim to the debt. Contesting the debt with a written statement is, in law, absolutely effective as a means of rebutting the presumption and removes the implication that this undisclosed third party may have procured the claim on the debt by tacitus means. Tacitus. It is unlawful because in order for a contract to be binding and enforceable, there must be a meeting of the minds or full disclosure and transparency. A party to a contract that sells off their interest to a new party without express consent of all parties involved, which means your explicit consent, is unenforceable in law unless you unwittingly allow them tacit procuration by not rebutting their presumptions and responding to their offer to contract. Under the UCC, you must assert your rights in advance of any presumptive circumstance in order to secure them. What is a presumptive circumstance? When you are pulled over and you hand the police officer your corporate identification documents, your driver's license, there is presumption you are working for the United States, Inc., or an agent of government knowingly consenting to be subject to all statutes and rules under their corporate system. It's as if you are saying, because I wear Nike shoes, I work for Nike and have to follow the rules as an employee of Nike. I reserve my rights without prejudice. UCC 1-308. Okay. This is the state of affairs on the planet. Deceptive acts and practices. It is this same system that now reconciled on people's public trust used to foreclose on all banks and corporations masquerading as governments in late 2012. A statement of I reserve all rights without prejudice, i.e. UCC 308 prevents any presumptive contracts from being asserted. However, actually using this can be more complex. One should be well prepared with key knowledge and understanding before trying to apply anything that goes against the grain, in my opinion. It is important to understand our society is based mainly on these presumptive offers to contract. The IRS is a prime example of an unlawful presumptive organization. It asserts the presumption that you are a taxpayer when under all the statutes of the US, we are taxpayers and only pay taxes by government granted privileges, i.e., you are an agent of government or you are earning income in a way that was enabled by the government. Tax shelter from foreign earned income, for example. Hold on. Let me read something again. It says, the IRS is a prime example of an unlawful presumptive organization. It asserts the presumption that it asserts the presumption you are a taxpayer when under all the statutes of the US, we are taxpayers and only pay taxes by government granted privilege, i.e., you are an agent of government or you are earning income in a way that was enabled by government. For an example, tax shelter from foreign earned income. Okay. All right. Here is what without prejudice UCC 1-308 means from the UCC. Performance or acceptance under reservation of rights. A party that with explicit reservation of rights performs or promises performance of or assents to performance in a manner demanded offered by the other party, does not hereby prejudice the rights reserved. Such words as without prejudice or under protest or the like are sufficient. The method of articulation seems intentionally cryptic. They are trying to hide the meaning in plain sight. Let's analyze. Explicit reservation of rights means you make a statement just like they make statements, that your rights are totally yours without any presumption to the contrary. Performs or promises performance or assents to performance in a manner demanded or offered by the other party means if you get duped or coerced into an agreement, even if you were not aware of it, the agreement will not be enforceable under the UCC system if you assert your rights beforehand. Without prejudice, UCC 1-308. There are presumptions to contract everywhere in society. The UCC is designed to be based on statements which go unrebutted and then become enforceable. Transparency is your friend. And as we often say here on SITS, whatever that is, know thyself. Be aware of who you are and how that beingness extends outwardly everywhere. There is only one of us after all, and this one makes up all things. You are your greatest asset, and investing in the knowledge of yourself and how that relates to this world you live in and how it works will be your greatest tool. Okay. Trust me, man. I know this shit can be kind of confusing. Again, I've given you guys plenty of warnings about this law shit when I told you it's not sweet. You know, it requires hours, days, weeks, months, and even years of dedicated study and research to enter, and understand this legalese and these legal words that have dual meanings. In a regular dictionary, they'll have one meaning, but in a legal dictionary, excuse me, they'll have another. And it's up to us as individuals to ascertain the meaning of a word when it's being used, depending on the context. All right, so listen, let me see. I think I'm going to read a little bit more, and I'm going to cut this one off, and I have to come back and do a part 2. I'll read the UCC connection forward, and then I'll come back on another, video and get deeper into it. All right. This is slightly condensed, casually paraphrased transcript of tapes of a seminar given in 1990 by Howard Freeman. It was prepared to make available the knowledge and experience of Mr. Freeman in his search for an accessible and understandable explanation of the confusing state of the government and the courts. It should be helpful to those who may have difficulty learning from such lectures, or those who want to develop a deeper understanding of this information without having to listen to 3 or 4 hours of recorded material. I happen to not be one of those individuals. I will listen, pause, and take notes. See, because I understand that you got to get this kind of information where you can, and it's your duty and obligation to research it from there, to ascertain its validity in law or the lack thereof. So okay. Let me light this cigarette first. Oh, excuse me, I'm getting tired. All right. The frustration many Americans feel about our judicial system can be overwhelming and often frightening. And like most fear, eventually, with the seemingly tyrannical power of some governmental agency and the mystifying and awesome power of the courts, we have been taught that we must get a good lawyer. But that is becoming increasingly difficult, if not impossible. If we are defending ourselves from the government, we find that the lawyers quickly take our money and then tell us the ship is sinking. Oh, and then tell us as the ship is sinking, I can't help you with that. I'm an officer of the court. You see what I'm saying? See, the questions that we starting to ask these clowns is getting more to the point, and I try to warn, individuals that I have these types of conversations with on a regular basis, man. The lawyer and the judge are going to protect each other because they're fraternity brothers. And them two are going to protect the police officer. They're fraternity brothers. Give a fuck how much money you pay them. Believe this shit or not. Just don't wait till you're in a perplexing situation and you done paid them, upwards of $30,000, $40,000 just for them to tell you the same shit. I'm an officer of the court. I can't go. I can't. Yeah, that's your ass. So, But then again, man, this type of information is only for those that are seeking. It's only gonna, if it don't resonate with you, then it ain't for you. But on the other hand, if it resonates with you, check it out, man. It says, unfortunately, the only way for us to have even a snowball's chance is to understand the rules of the game and then play the game by the rules. All right. And to come out, and to come to an understanding of the true nature of the law. The attorney lawyers have established and secured a virtual monopoly over this area of human knowledge by implying that the subject is too difficult for the average person to understand, and by creating a separate vocabulary out of English words of otherwise common usage, while it may at times seemingly hopeless. While it may at times seem hopelessly complicated, it is not that difficult to grasp. Are lawyers really as smart as they would have us believe? Fuck no. Hell no. They people just like us. All they do is, believe it or not, it's a curriculum they learn from. What does that tell me? That tells me that they force feed themselves a bunch of information and documentation and portions of books, definitions, etc., and they regurgitate them to pass a test. And they, beyond that, largely memorize things in order to know how to applicably utilize said information to get a desired result in a so-called court of law. You dig? So let me get back to it. Besides, anyone who has been through a legal battle against the government with the aid of a lawyer has come to realize that lawyers learn about procedure, not about law. Mr. Freeman admits that he is not a lawyer, and as much he has a way of explaining law to us that puts it well within our reach. Consider also that the framers of the Constitution wrote in a language simple enough that the people could understand, specifically so that it would not have to be interpreted. So again, we find, as in many other areas of life, that the buck stops here. It is we who must take the responsibility for finding and putting to good use the truth. It is we who must claim and defend our God-given rights and our freedom from those who would take from us. It is we who must protect ourselves, our families, and our posterity from the inevitable intrusion into our lives by those who live parasitically off the labor, skills, and talents of others. Read that again. It is we who must protect ourselves, our families, and our posterity from the inevitable intrusion into our lives by those who live parasitically off the labor, skills, and talents of others. Others being the population. Anybody outside of having a piece of paper stating that you've passed the bar. And trust me, I've seen lawyers make silly oversights that have caused cases to be overturned. Anyway, To these ends, Mr. Freedom offers a sample, hopeful explanation of our plight and a peaceful method of dealing with it. Please take note that this lecture presents one chapter in the book of his understanding, which he is always refining, expanding, improving. It is, as all bits of wisdom are, a point of departure from which to begin our own journey into understanding, that we all might be able to pass on to others greater knowledge and hope. And it says, and to God, the gift of lives, the gift of lives and peace, freedom and praise, or whatever. I send you out as sheep in the midst of wolves. Be wise as a serpent and harmless as a dove. Okay. That will conclude this portion of the reading. There are deeper understandings to be had. There's a deeper significance to be sought in what I've read thus far. It is upon you, the viewer, to decode or ponder upon, to grasp the deeper understanding of the aforementioned. And what you can be prepared to hear about is public law versus public policy. 1938 in the Erie Railroad, that's a popular case. Anybody that's been locked up and did their own research, and anybody that's been to a law library, I'm pretty sure you've heard about the Erie Railroad case. A friend in the court, it goes on to talk about America is bankrupt, and America is not bankrupt. The United States is bankrupt. They are two separate situations. Again, America is a nation. When have you ever known a nation to have a president? Companies have those. Corporations have those. Know the difference. Then it gets into admiralty courts, jurisdiction, common law. This thing gonna get deep, so it's gonna be a part 2, man. Hopefully, again, if you have no prior knowledge of law, then don't feel bad if you don't really understand. All I could tell you is rewind it and listen to it again, man. I made it a point to not read it fast as I'm capable of reading for a reason. And if you pay attention to when I'm reading, I'll stop and give you a certain look, or I'll put emphasis on stuff. Those are the key terms that you need to pay attention to, if not look up. And I want to put extra emphasis on when you look these things up. Make sure to verbalize the legal definition. And then if you have to look further, once that first new page comes up, the deeper you go, the more it expounds on the definition. You may end up getting the actual literal legal definition. That's for those of us who don't have the books. So again, man, based on the description of this page, this is one of the things that I told you that I will be delving into. It's imperative for the average layman that feels like I do. Who the fuck are these faggots to keep, dictating to me who and what I'm supposed to be or what I'm supposed to do, how I'm going to do? Man, fuck you. And that shit you talking. You dig what I'm saying? At the end of the day, man, a lot of y'all may, bypass this, and that's cool. It ain't for everybody. But, it has to start somewhere, man. We've been fucking with these lawyers in these courts, in this government, for how many centuries? How come we ain't advanced yet? I ain't never voted. Matter of fact, I'm lying. I voted one time when I was in Glen Mills, and that's because I ain't know no goddamn better. But at the end of the day, man, what has it done for us? The fuck has it done for us? Exactly. Anyway, man, I know a lot of people don't, subscribe to, the way my school of thought or the way I view things, and I'm cool with that. I ain't asked for no assistance. I ain't asked for no help. I ain't asked for you to validate my position. So if it resonates, that's what's up. If it don't, find something else that you can entertain yourself with and be alright with that. Out.